Dear students, today we will be doing the second chapter of your company law book, that is company management and administration. So it is very much clear with each one of you that actually the virtual owners of company are its shareholders, and they have the right to manage the affairs of company, but it is not practical, it is not feasible for the shareholders to manage the affairs of the company, as they are scattered all over and they are very large in number. So what the shareholders do, they transfer their right of managing and administering the affairs of the company to the directors. So, here what we say, when the group of persons who manage and administer the company's affairs is known as board of directors. So, a company board of directors is a supreme body for its management and administration. And what do these board of directors do? They appoint a managing director and a secretary. And dear students, under the Companies Act, the board of directors is a must for the management and administration of a company, and other kinds of managerial activities like managing directors or a manager are optional, though the company may or may not have them. So, up till now, it has been very clear that because the shareholders are scattered all over, but they have the right to manage the affairs of the company, but then it is not feasible for them to manage the company, so they transfer their right to the directors who administer and manage the affairs of the company. Now let's know who are the board of directors. So according to section 149 of Companies Act 2013, it says that every company shall have 3 directors in case of a public company and 2 directors in the case of a private company. And if the company is one person company, then only one director is needed. The maximum number of directors in a company are 15, and the companies may appoint more than 15 directors, but for this they have to pass a special resolution in the meeting, and among those it is compulsory to have at least one women director. And next provision states that at least one director should have stayed in India for not less than 180 days in the previous calendar year. And every listed public company shall have at least 1/3 of the total number of directors as independent directors. Even the section 150 of Companies Act also describe the manner and the procedure for selection of independent directors and the maintenance of data bank of such directors. Section 151 also provides the way the appointment of directors will be done who are elected by the small shareholders. And a listed company must have one director elected by small shareholders on its board. So here what we mean by small shareholder, a small shareholder is the one shareholder who is holding shares of nominal value of not more than 20,000 rupees or any other sum which is prescribed there. अब बात करते हैं 1 person कंपनी की. In case of a 1 person company, an individual who is a member, he would be deemed to be the first director until the director or directors are appointed by members under section 152 subsection 1 of Companies Act 2013. Now it is very important according to section 152 that who can be a director. So here only individual can be director. This means no body corporate, no association or a firm can be appointed as a director. Only an individual can be appointed as a director. and as a director, this individual will be functioning on its own and will be personally responsible for all of his actions as a director. Section 158 states that no company shall appoint or reappoint any individual unless he has been allotted a DIN. So here DIN is Director Identification Number. So whenever any individual becomes a director, at the same moment he is allotted a number, and his identity is not through his name but through this number, and this number is known as DIN, that is Director Identification Number. Now next, restriction on number of directorship. So dear students, here section 165 of Companies Act 2013 provides that no person shall hold office as director in more than 20 public companies anytime. In case if he has become the director of more than 20 companies, like if we say 21 companies, then he has to resign from that 21st any one of these 21 companies, and the maximum number cannot be more than 20 public companies under section 165. Even the same section states that maximum number of directorship that an individual can hold, including alternate directorship, is 20, of which not more than 10 can be public companies. And in counting the limit of these public companies, the directorship of private companies which are either holding or subsidiary company of a public company shall be included. Now switching to the qualification of director. So this is very important topic which says ki who all are qualified to become the director of a company. Dear student, though the Companies Act has not defined any qualification of a director, nor it has specified that a director may be a shareholder of the company, but it is a common belief, everybody thinks that the director must be a shareholder of the company. Though this belief is mistaken, unless there is nothing to the contrary in the article of association, a director need not be a shareholder of the company. This means that कि कंपनीज एक्ट के अंदर कोई भी डायरेक्टर के क्वालिफिकेशन मेंशन नहीं है, और ये कॉमन बिलीफ है कि एक डायरेक्टर को शेयर होल्डर होना चाहिए, बट अदरवाइज दिस बिलीफ इज मिस्टेकन. Until and unless it is written in the article of association, एक डायरेक्टर के लिए ज़रूरी नहीं है कि वो एक कंपनी का शेयर होल्डर हो, but article of association has defined the qualification shares of its director, and these are the few of the rules which govern the appointment of a director, which says that no person can be appointed as a director of a public company unless he has a DIN number. He is given a consent which is signed by him and submitted with the registrar of a company, where he says that he is ready to act as a director within 30 days of his appointment. Then he has signed memorandum of association for qualification shares, and he has agreed to pay for those qualification shares. A written undertaking is being signed by him, and he has submitted that undertaking with the registrar that he agrees to take qualification shares and is ready to pay for them. Another affidavit which is filed with the registrar to the effect that his qualification shares are registered in his name. So these all provisions relate with the qualification of directors. Now let's switch to the disqualification of directors. So all the disqualifications of directors are given in the section 164, which says if no person can become the director if he is of unsound mind, if he is insolvent, if he is convicted by court, or if he has some cause in errors, or in case a court or tribunal has passed an order that he is disqualified to be as a director and the order is still in the force. Thank you. Have a nice day. In case you have any doubts, you can post in your WhatsApp group. Thank you and have a nice day.